Hello, everyone, and welcome to Uncivil Law. For today's case, we have a continuing reminder that you shouldn't talk to the police. This is United States of America versus Lee Blomquist. In this case, the police came to Lee's house on suspicion that he had marijuana. He did have marijuana, quite a lot of marijuana, as it turns out. And then he offered to give the police a guided tour. And the government wants to admit this evidence against him. And he says, that's not fair. They didn't have a warrant. And the United States government and the Court of Appeals has to explain to him that, you consented. So the evidence can be used against you. Don't talk to the police. Let's get started with this. Blomquist was storing marijuana on his father's property. The police got a warrant to search that property after watching the suspicious comings and goings of a drug dealer. The warrant permitted a full search of the property, including any outbuildings found within its curtilage. When the officers arrived, they encountered Blomquist walking out of a nearby chicken coop. He has chickens, or at least a chicken coop, and placed him in handcuffs. The officers then advised him of his rights, and he waived them and agreed to talk. He was very cooperative, apparently, and at some point the officers removed his handcuffs because he was being so helpful. Blomquist claimed that he was running a legal medical marijuana operation and offered to show the officers his paperwork. He then took the officers to his father's garage and gave them a binder of materials in which he said authorized a medical marijuana operation. Okay, so this guy's off to a super promising start. The police come here with the search warrant, and he says, let me give you this document. Let me give you all these documents. I'll just hand them to you. And also, would you like me to show you around a little bit? The police are like, yes, please. Please show us around. So they're going to do that. The officers asked Blomquist where he stored the processed marijuana, and the tour continued. A very helpful tour guide indeed. He brought them back to his father's garage, pulled down a ladder, and led them up to a locked room in his attic. He unlocked the door and he let them in. The room contained around 37 pounds of marijuana, pre-packaged into baggies. Go big or go home. But since this is his home, I don't know what the right expression is, but whatever. As it turns out, and this will surprise probably no one, his operation was not exactly legal, not even under Michigan law. To start with, Blomquist was categorically forbidden from distributing medical marijuana in the state because he had a felony drug conviction of record. But even if he could run a legal operation, which he couldn't because of the felony drug conviction, his operation was too big. He stored more marijuana on his father's property than distributors were allowed to possess. 37 pounds does sound like a lot, yes. And if that wasn't enough, he admitted to selling his marijuana not so much for medical purposes, but to a drug dealer who lacked the requisite medical marijuana card. So this guy's like, I'm running a medical marijuana operation in compliance with state law. No, not really. You're a felon, and also you're selling them to drug dealers. That isn't a legal operation. That's just trafficking in drugs. 37 pounds of marijuana. That's a lot. That's a lot of felony. Yeah. Okay. Great. Way to go. Blomquist has also broken a host of federal laws, you don't say, and federal prosecutors charge him with manufacturing, possessing, distributing, and conspiring to distribute marijuana. Blomquist moved to suppress the evidence obtained during the search. On what basis? At the suppression hearing, Blomquist established that the chicken coop and greenhouses were on his cousin's property, which he leased and was not covered by the search warrant. So the chicken coop that would contain the drugs wasn't within the search warrant. So if the police had found it on their own and had searched it improperly, it'd be a violation of the warrant. Now, that may or may not matter in the end for a whole host of reasons, but at least he'd have an argument, but not so much because he just showed them the way. So he argued the officers knowingly exceeded the scope of the warrant. Okay, you know right away you're in trouble. First of all, they probably didn't knowingly exceed it because where the boundary lines of the property are a little bit vague. But even if they did knowingly exceed the warrant, it doesn't matter. You know why it doesn't matter? Because you consented. You said, please, officers, please come this way. Let me show you my chicken coop. Let me show you the drugs. You don't need a warrant for that. Yeah. Because Blomquist voluntarily consented to the motion by giving the detectives a guided tour, the district court denied the motion to suppress, because of course they did, and Blomquist now appeals. He appeals. He's sad. The court's going to tell him he has no choice but to be sad, I guess. Since consent is a question of fact, we look at the evidence in the light most favorable to the government and reverse only for clear error. For consent to be valid, it must be free and voluntary. Thus, we ask two questions: whether an individual's actions adequately demonstrate consent, and whether other factors contaminated that consent. First, did his actions demonstrate consent? In short, yes. After the police secured Blomquist and informed him of his rights, which said, everything you say will be held against you, he volunteered to show them his papers. The police examined the papers and asked Blomquist if he would show them his operation. He agreed as Blomquist counsel, and he took the police around on his property. Please come this way, fellow officers. Please see my operations. Isn't it a lovely operation, officers? It is very lovely, I'm sure. Blomquist led, and the officers then followed. The officers never forced their way into any outbuildings, told Blomquist that they go in without his permission, or stated that their warrant enabled such a search. Instead, a magistrate judge aptly described Blomquist as giving the officers a tour of his operation. Not only did Blomquist consent to the search, he practically directed it. In the very literal sense of the word practically. He directed it very practically, extremely practically. Yeah. The second question we must ask is whether other factors contaminated the consent. We determine whether consent is voluntary by looking to the totality of the circumstances. We consider factors such as age, intelligence, and education, where the individual understands the right to refuse consent, where the individual understands his rights, the length and nature of detention, and the use of any coercion or punishing conduct by the police. Blomquist contends his consent was not voluntary because he was detained when the police arrived, and because the police improperly relied on the warrant. The police absolutely did not improperly rely on the warrant. You know what they relied on? You saying, please come this way. Please come this way, fellow officers. Let me show you all the things. That would be what they relied on. The district court disagrees, and so do we. So does everyone else with a brain. For starters, although Blomquist was briefly detained by law enforcement officials, he was given his Miranda warning. That was his clue to shut up. He decided to not do that. Okay. He was thus fully aware that anything he shared with the officers could be used against him. And still he led the officers on a tour of the chicken coop and the greenhouses, explaining in detail exactly how it worked. While the officers did ask Blomquist if he'd show them where he grew his marijuana, they didn't force him to do so or threaten him in any way. What's more, Blomquist was cooperative from the get-go. Why? Because, as his attorney explained in sentencing, he thought his operation was mostly legal under medical marijuana law. For what it's worth here, I don't know if this memo is still operative, and I think it is, but someone will double check me. But the Obama administration wrote a directive to the U.S. attorneys that basically said if a person is in perfect compliance with a state law, the U.S. attorney should not prosecute them. And there actually have been court cases on this, incidentally, where the courts have said, first of all, this letter isn't controlling. It's just a recommendation. But even if it were, the letter says by its own term you have to be in perfect compliance with the state law. So if his argument was, I'm mostly in compliance with the state law, you know what that means? You weren't in compliance with the state law. That would be what that means. It also means that you weren't in compliance with the federal law. You knew that to start with. And also, you weren't in compliance with the memo, which required you to be in perfect compliance with the law. So I was most of the way there. In sum, the totality of the circumstances shows that Blomquist's consent was voluntary. When the officers arrived, Blomquist sized up the situation, decided he was best off cooperating, and consented to the search of his chicken coop and its greenhouse. His Fourth Amendment rights were not violated, and the district court correctly denied the motion to suppress. We affirm. As must we all. This is pretty easy. Thus, that brings us to the end of the case of United States of America versus Lee Edward Blomquist, a guy who was operating a fairly notable marijuana operation. Unfortunately, he was doing so super illegally, both under state law and, of course, under federal law. And the police came and executed a search warrant. And he said, please, officers, let me give you all the documentation that shows exactly what I've been doing in copious details. And let me show you all the things, and my chicken coop, and the addict, and the 37 pounds of marijuana already distributed. Aren't you so pleased at my operation? And the police were probably very, very pleased indeed. And then he goes to federal court, and the federal government's like, yeah, no. And he's sad, and the federal government has to explain to him how consent works. When you say, when you not only say yes, but please let me show you the way, consent's kind of easy. So, enjoy your time in federal prison. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.